Hear me?
Yes, Your Honor.
Okay, good morning, everyone. I'm Judge Epperson. You can mute that while I'm talking, so give me the feedback. You can still hear me though, right? All right, folks, good morning. I'm Judge Epperson. We're here for initial appearances, which is a very brief hearing for the limited purpose of the court determining probable cause for your arrest. And if there is probable cause, whether or not bond's appropriate, if so, how much and what conditions of release might be appropriate. Each of you has the right to an attorney, and I'll be making a provisional appointment to the Public Defender's Office today for initial appearance. You have the right to remain silent. Anything you say could be used against you in a future proceeding by the state. We have a prosecutor here, Mr. Horn, I believe, from the State Attorney's Office. And so you have the right to remain silent other than answering any questions I might ask you about your identification. You also have the right to communicate with friends and family concerning your case, subject to the reasonable restrictions of the jail. When I call your name, just come directly to the podium and we'll hold your initial appearance. Before we do, though, I do want to have personnel put their names on the record. First of all, at the Osceola County Jail, we have Assistant Public Defender. If you could announce your presence.
Yes, Your Honor. Admin usage for the Public Defender's Office.
And for the State Attorney's Office today.
Daniel Horn on behalf of the state of Florida.
All right, and we also have Assistant Public Defender as well here in Orange.
Caleb Robinson on behalf of the Public Defender.
Okay, let's begin. Luis Acevedo Lugo. All right, good morning, Mr. Acevedo.
Good morning.
Been arrested on a warrant for degree murder. Your bond will remain zero until the time public defender is appointed. Your next court date will be provided. Thank you.
Your Honor, I couldn't hear a word of what you just said.
You couldn't hear what I said?
At all, yeah.
Okay, is that better?
Yes, Judge.
Okay, so defendant was arrested on a warrant for first degree murder, and the bond is zero, will remain zero for now. Defendant has public defender appointed, and the next court date will be provided.
Thank you, Judge.
All right, so going next to Heriberto Almonte. Heriberto Almonte is coming forward. One moment. Mr. Almonte, I've reviewed the police report. I find probable cause for battery. I'm setting your bond at the amount of $1,000. You're to have no contact with Tina Deber Ardinas, not to return to the Sun Inn located at 5020 West Earlo Bronson Highway. If you have personal belongings like clothing at that location, then I'd grant a one-time return with the assistance of the Sheriff's Office. You're not to possess any weapons or firearms. Your next court date will be provided. All right, thank you. Jennifer Aquino. Good morning.
Good morning.
Ms. Aquino, you've been arrested on an out-of-county warrant, a violation of probation on it. Actually, it's an Osceola. Let's see. There's the Palm Beach.
It's on Palm Beach, Your Honor.
Yeah, just a moment. Okay, so you've been arrested on an out-of-county warrant for a violation of probation on a DUI case. Your bond is zero. Palm Beach will have 72 hours to pick you up. Thank you.
Yeah, Your Honor.
Are you appointed to the out-of-county?
Yeah.
No? Okay. Thank you.
Let me go off. I'm going off speaker. Are they doing that typically now for these out-of-county?
Yes.
Yeah. All right, because of the COVID situation, I know that we're making provisional appointments these days on out-of-county warrants as well, because sometimes there's communication and dispositions that are resolved. So on that last case, Defender Aquino, I'll provisionally appoint the public defender. Turning next to Jose Arce Rodriguez.
Your Honor, this will be a Spanish interpreter case. May we save this for last?
We'll come back to him. Santase. Louis Burkowski. Burkowski, I'll appoint the public defender to represent you in this matter. You've been arrested on a violation of probation allegation underlying charge DUI in case 20 CT 181. Your bond is $0. It will remain $0 at this time. Your next court date will be provided. Thank you. Joel Castillo Agramonte.
Your Honor, this is another Spanish interpreter case, if we can save this for last.
All right, Siéntese. Brittany Craddock. All right, good morning.
Good morning.
Craddock, you've been arrested on warrants from another county, that's Broward County. You can mute the feedback there. All right, the Broward County Court has given you a bond of $1,000 on each count for an aggregate of $3,000 because it's three counts in the warrant. Broward County will have 72 hours to pick you up. I am provisionally appointing the public defender to represent you in the matter. Thank you. Magali DeVille. All right, good morning. Ms. DeVille, court finds probable cause for battery. Just a moment. Setting bond at $500. You're to have no hostile contact with Gene DeVille. I realize that's your brother, I believe. You're to have no hostile contact with him. You're not to possess any weapons or firearms. Given the totality of circumstances, I'm not going to do a no return. Your next court date will be provided. Public defender is appointed. Jermaine Ingram. Public defenders provisionally appointed. Hello. Mr. Ingram, I do find probable cause for possession of synthetic cannabis and possession of drug paraphernalia. On the synthetic cannabis charge, I'll change the bond to $1,000 on count 1, $500 on count 2 for possession of drug paraphernalia. Unfortunately, you're out on bond in case 20 CF 3550 for similar offenses. Your bond in that case will be revoked. You'll be held on a $0 bond on that case, and I'll appoint the public defender in that matter as well, if not already appointed. Your next court dates to be provided.
Your Honor, may I be heard as the probable cause on this case?
Certainly.
Your Honor, according to the arrest affidavit, the initial interaction was on February 14th, and then the arrest didn't occur until the 27th. We would argue that it has gone stale at that point. He also did say he tried to make contact, but was not provided with any contact information for the arresting officers at that time.
And when I made contact, they brought me to jail, sir. I did what I was supposed to do, sir.
All right. How does the 13-day passage of time, Mr. Usich, result in the dissolution of probable cause?
My brother and his
Let's talk
girlfriend.
to your attorney.
Your Honor, he did inform me that he tried to make contact with the law enforcement officers, and he's saying that he was arrested 14 days later.
Yes, sir. The chick put that, the Mexican. But I want to tell
Okay,
him,
go
sir.
ahead,
I
go
just
ahead.
want to tell him what happened, sir. Sir, the officer said body for body, and I said, sir, if I give you submission, I'll contact you. He called my mama and my brother, and when they told me, and when I went, I saw the sergeant at Mexican Chipotle Grill, him and 2 other sergeants. I went between the cars and said, sir, I need to speak to Mr. Rodriguez. He said, there's 60 officers. I said, he right with C. Jordan. They said, hold on, sir. I could have ran and did anything, sir. I waited with my niece and they brought me to fucking jail, bro. That ain't right, sir. I did what I had to do, bro. They didn't give me no car and no response, sir. I did what I had to do, bro. I lost everything, sir. I'm in jail and I did the right thing, sir.
All
I
right.
did the right thing.
I do see in the police report you indicate that the officers were considering deferring an arrest,
See?
perhaps in view of some cooperation. That doesn't change the probable cause finding, however.
But
Right?
every day, sir, I tried to contact this man. Every day when the sergeants told me to wait, I waited. They said he wanted to talk to me. They brought me to jail, sir.
All right.
They have nothing on me. I work every day, sir.
What you're going to have to do is talk to your lawyer to reach out to law enforcement, but at this point in time, the probable cause finding is all I'm handling right now, so that does conclude this hearing. All right, good luck. Christopher,
Count two is stated 500, correct?
yes, count two, stated 500. All right, Christopher Mihalik. All right, Mr. Mihalik, I'll appoint the public defender to represent you in the matter. I have reviewed the police report and find probable cause for possession of a controlled substance, that is methamphetamine, and count two, possession of drug paraphernalia. Just one moment. Looks like there's out-of-state warrants in the case. Your bond will remain $2,500 on count one and $500 on count two. As a condition of release, should you make bond, you're not to possess, ingest, or consume any illegal substances or any controlled substances without a prescription. Your next court date will be provided. Thank you.
Say something? Can I say something?
Sure.
The out-of-state issues all are to be scheduled. I have a surgery that is due Thursday. Missouri issue, I'm going to go on the 28th, and that'll be dropped. If there's any considerations you can have, because I have a stricture of my urinary tract, you can check with my medical records. I have to have the surgery done next Thursday. It does with my condition to use the bathroom and expel feces from my body. I'm not a flight risk. I'm here to have that surgery done, and I'm communicating with other agencies to get that stuff taken care of.
All right, that sounds like it's a very important matter to you, and your attorney can seek a modification of your bond conditions with the trial court. Thank you. Mackenzie Mahalik.
Your Honor, we'll be recalling her at the end due to a relationship with another inmate here.
Ronald Morrow. Ronald Morrow. All right, Mr. Morrow, good morning. I've read the police report. I find probable cause for the offense of battery. Just one moment. Setting your bond at $750 and placing you on, that's bond with pretrial release with the following conditions. You're to have no contact whatsoever with Ms. Lacey Morrow. You're not to return until further order of the court. You're not to return to 5211 Sunset Canyon in Kissimmee. If you have personal belongings there, which I presume you must, such as clothing, toiletries, things for your work, I would grant a one-time return with the assistance of the sheriff's office. You're not to possess any weapons or firearms, and your next court date will be provided.
Your Honor, may I be here to pretrial conditions?
Yes, and go ahead, Mr. Usich.
The alleged victim in this case apparently has left the state, so we would ask if he be allowed to return to the scene since that is his primary residence.
Okay, that would be an issue that would be considered by a court at a hearing where sworn testimony could be taken to establish either the facts in support of that or not in support of that, but I'm not going to alter what I've done today. All right, thank you. Candice Romdeo.
Your Honor, she will be recalled at the end.
Vanessa Rivera Colon. All right, good morning. Just a moment. All right, Ms. Rivera Colon, having read the sworn affidavit, I find probable cause for the battery domestic allegation. I'm setting your bond in the amount of $750 with pretrial release conditions. You're to have no contact with Edwin, this is a pretrial release supervision, no contact with Edwin Vasquez. You're not to return to 4090 Enchanted Oaks until further order of the court. If you have personal belongings there, such as your clothing, toiletries, things for work, then you can return one time with the assistance of the sheriff's office. And you're also not to possess or consume any alcoholic beverages as a condition of your release. Your next court date will be provided and the public defender is appointed to represent you. Thank you. Nicole Rodriguez.
Your Honor, I apologize. This is another Spanish interpreter case.
Okay,
She's saying she's comfortable with her English.
Okay.
Point-
just a moment. All right, Ms. Rodriguez, I've reviewed the police report. I do find probable cause for the listed offense of aggravated battery. Your bond in the case, I'll set at $1,000. Supervised by pretrial release supervision. You're to have no contact whatsoever with Robin McIntyre. I realize you live in the same community apparently, but you must have no contact, and that means no communications, third party or otherwise, and you're going to get a very detailed order spelling that out. You must not possess any weapons or firearms. Again, the public defender has been appointed to represent you, and your next court date will be provided. Thank you.
Your Honor, may I be heard as the probable cause on this case?
Sure.
Regarding the element of a deadly weapon, it does state that it was a broom used in this. Defense would argue that would not be considered as a deadly weapon. We would argue there's PC for battery, but not for battery with a deadly weapon, Your Honor.
All right, State, have any response?
Your Honor, I'm pretty sure the case is
Can you mute so I can hear the State, and I'm sure you can too?
Your
Go ahead,
Honor, I'm pretty
State.
sure the case law is very specific that anything can constitute a deadly weapon when used for a battery, Your Honor.
Well, I don't read it the same way as anything, but let me take a second look at the report. As I recall, the victim was allegedly being struck repeatedly with such force that the broom even broke. Just a moment. Yeah. All right, according to the allegations, the defendant was allegedly striking the victim repeatedly with the hard portion of the broom with such force causing the broom to break, and that it left a very visible injury, a knot on the forearm of the victim. And so the question is whether or not the broom was used in a manner that was likely to cause great bodily harm. I find on a probable cause threshold that that's sufficiently established, although certainly that could be an issue argued before the jury on a standard of proof beyond all reasonable doubt. So I'm going to go ahead and maintain my findings. All right, thank you.
Thank you, Your Honor.
Anthony Sauer. Hello, Mr. Sauer. I will appoint the public defender to represent you in this case. I'm going to, in this particular matter, afford the state 24 hours to supplement the record, and this will be reset for tomorrow for a probable cause determination. State the basis for that. There's the use of the pronoun they, referring to this defendant and another party engaged in the commission of a burglary, and there's not particularized conduct ascribed to this particular individual. And then on the controlled substances, a search was allegedly conducted of Mr. Sauer, and there's not a sufficient basis providing the lawful grounds for that search in this affidavit. It says to refer to Corporal Ferry's supplement, which I don't have. So the bottom line is, Mr. Sauer, your case is being deferred for tomorrow for a probable cause determination, and the state can supplement the record. Your existing bonds will remain as they've been put on the charging affidavit: $3,500 on count 1, $250 on count 2, $2,500 on count 3, and $500 on count 4. All right, thank you. Public defenders appointed. Christy Serrano Lopez.
Your Honor, this will be a Spanish interpreter case.
Okay. Walter Smith. Mr. Smith, I will appoint the public defender to represent you. I've reviewed the contents of the police report. I do find probable cause for the 3 offenses: possession of methamphetamine, possession of drug paraphernalia, resisting an officer without violence. Bonds will remain as they've been set in the affidavit: $1,000 on count 1, $500 on the 2 remaining counts. Supervised by pretrial release. You're not to possess, ingest, or consume any illegal substances or any controlled substances without a prescription. Again, the public defender's been appointed, and your next court date will be provided.
Your Honor, may I be heard as the probable cause on this matter?
Yes, and if you have a probable cause argument, feel free to jump in before I do my.
I just didn't want to interrupt, Your Honor.
No, I understand. Perhaps I'll invite you to do that at the beginning of IAs in the future. But go ahead.
Will do, Your Honor. Regarding the 2 counts for the possession of drug paraphernalia, according to the 4 corners of the affidavit, when he was stopped, Mr. Smith was stopped, he was asked if he could be conduct a search of his persons. He declined. We argue that there was no probable cause for them to search his front jean pocket. If this was a pat-down for safety purposes, they should not have gone inside the pockets themselves, but simply patted on top of them. So with the evidence that was found in the pockets, we would argue was in lieu of a bad search, Your Honor. So no, we would argue there's no probable cause on that.
State's response.
Your Honor, my reading,
Just a moment. If you can mute at the jail so we can hear. Yeah,
Your
go
Honor,
ahead.
my reading of the affidavit says that he would consent to the search. I believe the search was consensual, and therefore, the officer could have checked his pocket.
All right, Mr. Usich, let me just ask your position on this. On paragraph 1, the officer in his affidavit says, I questioned Smith if he had anything in his possession that would get him in trouble and if he would consent to a search. Smith advised that he did not have anything on him and he would consent to a search. At this time, I began to check Smith's front right jean pocket. Smith then reached into his front jean pocket and handed me a glass pipe with powder residue. Now, I understand that I see your client shaking his head, and there can be a disagreement as to what actually transpired, but in terms of the 4 corners of the affidavit that you've just referenced, why is that not reasonably construed as a consent search?
Yes, Your Honor. I was also referencing to his statements previously to me. So regarding the 4 corners of the affidavit, we would drop the PC
All right.
argument.
All right, well, that certainly could be disputed in future proceedings, but I find probable cause, and the bonds will stand, and the next court date will be provided. Thank you. Dennis Tipton. Mr. Tipton, good morning. I've reviewed the police report. I find probable cause for theft and criminal mischief as alleged. Your bond will be $250 on the petty theft and $500 on the criminal mischief. You're not to return to the location of Publix at 3221 Vineland Road. Again, the public defender is appointed, and your next court date will be provided. Thank you. Okay, I want to go back to the other cases now, the Spanish interpreter cases, and then there were some other cases we decided to recall for whatever reason. Let me call the interpreter. Let's see, right here, okay. Okey doke.
Good morning, Your Honor. This is Laura Royal, State Certified Interpreter.
Good morning, Ms. Arroyo. If you could raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony, do you solemnly swear or affirm that you will faithfully translate from English to Spanish and Spanish to English to the best of your ability, so help you God?
Yes, Laura Royal, State Certified Interpreter.
Okay, we have a few cases for you. The first one, were at initial appearances, of course. The first one is Jose Arce Rodriguez, and he'll be coming forward now. Mr. Arce Rodriguez, can you please tell me your date of birth?
Señor Arce Rodríguez, por favor, ¿me podría usted indicar su fecha de nacimiento?
Speak.
Julio 3 del 97.
July 3rd, 97.
I find probable cause for operating a motor vehicle without having a valid Florida driver's license. Your bond on this case will be $500.
Se determina que existe indicios de criminalidad para sustentar la acusación de conducir sin licencia válida de la Florida y la fianza en la causa será $500.
You are currently out on bond for a felony traffic offense and other charges in 20 CF 3538. Your bond will be revoked in that case and you'll be held on a zero bond.
Usted ya se encontraba libre bajo fianza por un delito grave de tránsito y otros casos en el número 20 CF 38. Por lo tanto, se revoca la fianza y se encontrará usted detenido bajo prisión preventiva.
Public defender again has been appointed and your next court dates will be provided.
Se le ha designado defensor público y se le proveerá a usted las fechas de las próximas vistas.
Thank you.
Gracias.
Next case for our interpreter, I believe, is Joel Castillo Agramonte. He's coming forward. Mr. Castillo Agramonte, your date of birth?
Señor Castillo Agramante, su fecha de nacimiento.
Buenos días, su honor. Mi fecha de nacimiento es marzo 3, 98.
Good day, Your Honor. My date of birth is March the 3rd, 98.
All right. Good day, Mr. Castillo. You've been arrested on an alleged violation of probation in case 19 MM 4375. Your bond is zero on the violation of probation. Public defenders appointed, and your next court date will be provided.
Muy bien, señor. Buenos días. Usted fue detenido por incumplimiento de su régimen de libertad vigilada en el número de caso 19 MM 4375. Con respecto al acto de incumplimiento, no se le concede fianza y se le designará defensor público y además se le proveerá a usted las fechas de las próximas vistas.
Thank you.
Gracias.
Any other interpreter needs, Mr. Usich? I have Ms. Ramday and Ms. Mahalik.
Yes, Your Honor. Christy Serrano Lopez.
Oh, yes. Okay, Ms. Serrano Lopez is coming forward. Ms. Serrano Lopez, your date of birth?
Señora Serrano López, su fecha de nacimiento.
El 24 de junio del 97.
June 24, 97.
Ms. Serrano Lopez, I've reviewed the police report. I find probable cause for robbery by sudden snatching in count 1 and battery in count 2.
Señora Serrano, he leído el informe, el atestado policial y determinado que existe suficiente indicios de criminalidad para sustentar la acusación de robo al repentinamente robar el artículo y agresión física.
Given the lack of criminal history, I will reduce your bond on count 1 to $500. Count 2 battery will be $500. You're to have no contact whatsoever with Ms. Robin McIntyre. You're not to possess any weapons or firearms.
Muy bien, teniendo en cuenta la falta de antecedentes penales, se le designará fianza con respecto al primer cargo de $500 y $500 también con respecto al segundo cargo de agresión física. Usted estará prohibido tener ningún tipo de contacto en absoluto con la señora Robin McIntyre y prohibido la tenencia de armas o armas de fuego.
You will receive a written order which explains in detail how important this no contact order is and exactly what it means.
Usted recibirá por escrito y detallado la importancia de ningún tipo de contacto y lo que constituye esa orden de prohibición de contacto.
Thank you.
Gracias.
Mr. Usich, any other interpreter needs?
No other interpreter needs. We do have 2 other cases to be recalled, Your Honor.
Right. Okay, Ms. Arroyo, thank you. We're going to go ahead and excuse for now.
No problem.
Candace Ramdeo.
She's coming, Your Honor.
Hello, Ms. Ramdeo. I'm Judge Epperson. I've reviewed the police report. I'm appointing the public defender to represent you. I find probable cause for battery. Is there someone there from corrections, Ms. Dunkirk, or someone else?
Yes, Your Honor.
Yes, Your Honor.
I'm curious as to whether there's been any screening of this matter for possible special pretrial release consideration. I know she doesn't qualify for straight PTR. I was wondering if that was also an impediment to mental health PTR. You're muted, I believe. I don't know if anyone's speaking.
Due to her status within the jail, she doesn't qualify for PTR or mental health PTR.
That's not true.
She's currently in self-harm. So
That's not true,
until
you're
she's
lying.
evaluated by an outside mental health counselor and she gets cleared by the jail, then she could possibly be considered for mental health PTR.
All right, thank you. Ms. Ramdeo, I'm setting bond at $250. You're to have no contact with Jacqueline Gray. And again, the public defender is appointed to help you. Your next court date will be provided. Thank you. Next case will be Mackenzie Mihalik. All right, Ms. Mihalik, I have reviewed the police report. Public defenders appointed. I find probable cause for the offenses of battery in count 1 and aggravated assault in count 2. Your bond on count 1 will be $500, $1,000 on count 2. Should you make bond, you must have no contact with Mr. Christopher Mihalik. You must not return to the roadway inn at 7455 West Erlo Bronson Highway. If you have clothing there or personal belongings, I would grant a one-time return with the assistance of the sheriff's office, and your next court date will be provided. Thank you. I'm not hearing,
Don't talk about the case.
Can I put in for a fast and speedy trial today?
could she put in for, I didn't hear that, Mr. Eustace?
She wants to invoke her right to speedy trial, Your Honor.
She wants to do what?
She wants to invoke her right to speedy trial today.
Okay, your right has been so invoked, and the state must commence your prosecution within 90 days. So let's see. Yes, within 90 days of your arrest, and if they don't do so, your attorney can file a pleading with the court to consider getting your case dismissed. Thank you. Have we concluded Osceola? I think.
Your Honor, regarding Mackenzie, is there no contact with the alleged victim or no hostile contact with the alleged
There
victim?
was no contact.
No contact. Thank you, Your Honor. I think we've concluded everybody.
All right, have a good weekend, the rest of it. All right, thanks. All
Thank you, Your Honor. You as well.
right. Okay, all right.
So we're gonna go all the way through to Garcia and the misdemeanor, domestic?
We're gonna go all through what I've already read, yes, so we'll should we do interpreters first? Is that what we're gonna?
Interpreters, move ups, and then everything. at
That
the
I
beginning of
reviewed.
the list.
Yes.
So we'll stop at Garcia.
We'll stop at the last case I reviewed, which is, yes, Megan Garcia. Megan Garcia will be the last case, and then we'll take a break for people to eat while I keep reading.
500 and 1,000.
Thank you very much, ma'am.
You're welcome. It's misdemeanor domestic, Garcia is the last one.
So I need to get the interpreter back, right, in a minute?
Yes.
Mhm. These cases on top were the interpreters, yeah. I'll wait till the door opens. may ask for history. I know I have that stack of information, but if you could just use that microphone so I can hear it.
The TV.
It's not in the wave.
And then the.
You said you were doing first, domestics? No, I think he said interpreters first. I think so, right?
Yeah, Jose Amaya would be the first one. Let's go.
Thank you.
Good morning, this is the interpreter Laura Arroyo, state certified.
All right, I know Ms. Arroyo's previously been sworn, so we're going to continue with our initial appearances. We have the interpreter list first, all right?
Yes, Your Honor, I'm establishing connection with the podium right now.
Okay, and the defendant is about to put the headset on, and he's now wearing it. Let's confirm the connection.
Connection is established.
Sir, please tell me your name.
José Luis Amaya. José Luis Amaya.
Jose Amaya?
I'm Judge Epperson. I'm appointing the public defender to represent you in this matter provisionally. I find probable cause for battery, domestic violence. Setting your bond in this case in the amount of $1,000, you're to have no contact with Ms. Elizabeth Penalver. You're not to return to 5762 Shenandoah Way. If you have personal belongings there, such as clothing, toiletries, you may return one time with the assistance of the sheriff's office. You're not to possess any weapons or firearms. Your next court date will be provided to you. Thank you. That concludes our hearing today. Okay, the next individual is wearing the headset. Sir, can you please tell me your name?
Mi nombre es Alejandro Espinosa Gómez.
Alejandro Gomez?
Alejandro Espinosa Gómez.
I'm sorry, Your Honor, I'm getting an echo, so I can't catch the words.
Alejandro Espinosa Gómez.
Alejandro Pinoza Gomez.
Sí.
I'm Judge Epperson. I'm appointing the public defender to represent you in this case. Having reviewed this sworn report, I find probable cause for battery domestic violence. I believe we have present also Ms. Rosa Espinoza Hernandez. Is that correct?
Correcto.
Because you're the alleged victim in this case, you do have the right to be heard. Is there anything you want to say today?
I need to speak Spanish.
We have an interpreter, so you can speak Spanish.
Yes, thank you.
Is it possible for Ms. Arroyo to?
Yes, Your Honor.
Okay. Ms. Rosa Espinoza Hernandez is here and wishes to speak. Ma'am, you can address the court about this case if you would like.
Señora, usted tiene algo que quisiera decir, lo puede relatar, pero acérquese al micrófono.
¿Me puedo relatar aquí en el micrófono?
¿Cómo?
¿Me puede repetir la pregunta, por favor?
I'm sorry, Your Honor. I don't know if that microphone is working, but I cannot catch anything she's saying. I can hear her voice, but the words are undecipherable.
Okay, if you could tell her maybe to turn the microphone directly to her mouth.
Dirija el micrófono hacia su boca, por favor, señora, porque no entendí.
Okay.
Let's try again and see if that's better.
Intente nuevamente.
No tengo nada más que decir.
I have nothing else to say.
Okay, but you need to repeat what you said before because it was not translated for the court.
Your Honor, that was what she said.
Okay, all right, thank you. Does the state have any questions of the witness, victim,
No, Your Honor.
defense?
No, Your Honor.
Criminal history?
No, he doesn't have any history, Your Honor.
None?
None.
I'm setting bond at $250. Should you make bond, you're to have no hostile contact with Ms. Rosa Espinoza Hernandez. No hostile contact prohibits any acts of violence, but also prohibits any threats of violence or acts of intimidation. You're also not to possess any weapons or firearms. Your next court date will be provided.
Muy bien, se fijará en la presente causa una fianza de $250. Si usted logra depositar esa cantidad, sepa que está prohibido tener ningún tipo de contacto hostil con la señora Espinosa. No tener contacto hostil significa que no se permitirá ningún tipo de acto de violencia, amenazas de violencia o ningún tipo de acto de intimidación. También estará prohibida la tenencia de armas. La próxima fecha ante el juzgado se proveerá usted.
All right, thank you.
Gracias, señor.
Gracias.
Yo.
Okay, the next defendant is making his way into the courtroom and will be wearing the headset momentarily. He apparently bonded? No. Your name, sir?
Hector Medina.
I will appoint the public defender to represent you, Mr. Medina. I've reviewed the police report and find probable cause for grand theft. Pre-trial release, you have history for defendant?
No, he has no history.
One moment. Setting bond at $500. Mr. Medina, Should you make bond, you're not to return to the Macy's located at 8001 South Orange Blossom Trail. Your next court date will be provided. Public defender's been appointed.
Your Honor, can you also state if he can return back to Chile? He's not from here. So
Didn't hear you, I'm sorry.
He's on vacation here in Orlando.
Okay.
He's supposed to return back to Chile.
Okay.
So just state on the record if he can return or he has to stay.
I'm not going to require the defendant to surrender his passport under the circumstances. All right. But given those circumstances, I'll place the defendant on pretrial release supervision if he qualifies. Does he qualify?
Yes, Your Honor.
All right, so Mr. Medina,
Yes?
you may not return to Chile until this case is resolved, all right? You understand that?
Yes, I understand.
All right, thank you, sir. That concludes this hearing.
Oh, Judge, he cannot travel. Is that what you're, just can't return to Chile?
That's what I'm putting on there, yeah.
Okay.
Okay, moving along. All right, good morning, sir. Please state your name.
Manuel Rosas Flores.
I'm sorry, Your Honor, I'm having the same problem.
It's because the microphone is not, yeah, it's on top of his head. Just one moment. That'll probably do the trick. Please state your name again, sir.
Manuel Rosas Flores. Rosas Flores.
Manuel Rojo Flores.
Sir, you've been arrested for failing to appear on a trespass charge in case 20MM 6417. The trial court did give you a bond of $500. I'll provisionally appoint the public defender's office today. That's your bond amount. Your next court date will be provided. Thank you. You can now take off the headset. This doesn't need to be interpreted. Lazaro Rodriguez, I presume he must have bonded? Okay. One that bonded here. Good morning, sir. I'm Judge Epperson. Please tell me your name.
Lucas Pascual.
All right, Mr. Pascual Nolasco. The court finds probable cause for driving under the influence resulting in property damage, driving under the influence, and operating a motor vehicle without having a valid Florida driver's license. Case numbers 21 CT 1608, 1609, and 1610. Your bond on the DUI with property damage in the 1608 case will be $1,000. Your bond on the driving under the influence charge, which is 1609 case, will be $500. And your bond on operating a motor vehicle without having a valid driver's license, which is case 1610, will be $500. You'll also be placed on pretrial release supervision. You're not to possess or consume any alcoholic beverages, and you're not to go to any bars as a condition of your release. Your next court date will be provided. The public defender's been appointed to help you in the case. And this concludes the hearing. You can take off the headset. I think we have two more, Ms. Arroyo.
Yes, Your Honor.
Sir, please tell me your name.
Darling O'Kelly Erazo Santos. Darling O'Kelly Erazo Santos.
Berlin Okira Erasu Santos. Okeli.
Okay, sir, I'm Judge Epperson. Good morning. You've been arrested on an out-of-county warrant, a violation of probation on a DUI case out of Osceola County. Your bond on the violation of probation is 0. It's case 2011 TC 5273. Public Defender's Office is appointed. And Osceola County, if transportation is taking place, will have 24 hours to transport. But you also have a lawyer who can pursue the possibility of even a disposition. Your next court date will be provided. You can now take off the headset. You're welcome.
Okay, thank you.
You're welcome. I think I had one more interpreter case maybe. Is Hugo Perez? Yeah. What was that?
Yes, I do.
Okay. He'll be in a moment, I guess. Mhm. Good morning, sir. I'm Judge Epperson. Can you please tell me your name?
Perez?
Are you Hugo Perez?
Yes. Yes, sir.
Okay. Sir, you've been arrested on an out-of-county warrant from Osceola County in case 21 CF 529. It's a warrant involving 3 allegations, one being lewd and lascivious molestation on a victim under the age of 16. The other, a child abuse domestic violence case, and the third, exposure of sexual organs. The respective bonds for each of those cases will be 0 on count 1, 15,000 on count 2, and 1,000 on count 3. The public defender is appointed to help you and represent you in this case. Your next court date will be provided, and Osceola will be responsible for securing your transportation on these charges.
Judge, if I could just briefly ask that, we were just asked that Osceola has 24 hours to transport. I understand that COVID makes that a little bit more difficult. I would just like something on the record for a time limit for transport.
Well, being an adjacent county, I think the administrative order does say 24 hours. So if the counties are transporting, then Osceola must pick up within 24 hours. However, if there is a governing administrative order that that defers that due to COVID, then that would not result in the defendant's release. He would just have to come back before the court. Right?
Understood.
Thank you.
Thank you, Judge.
I believe that concludes our, sir, that concludes our hearing. You have a lawyer. You can now take off the headset. I believe that concludes our interpreter matters. Is that right?
Thank you.
Yes, Judge.
Thank you, Ms. Arroyo. Have a good rest of your weekend.
Thank you, Your Honor. Before I disconnect, I just want to confirm that there's no victim that's going to be requiring my services before I disconnect.
I don't believe so, no.
Okay.
You're free.
Thank
Thanks. All right. Okay, I'm ready to continue on. The next case would be Ms. or Rosa Moore, I believe. Hi, I'm Judge Epperson. Your name? Okay, Ms. Moore, I'm looking at your application for the public defender, and it says $1,700 is your take-home income, but you did not indicate whether that was weekly, every 2 weeks, monthly, or yearly.
Monthly.
Monthly? Okay. Based on your application, I will appoint the public defender to represent you, so you now have a lawyer Just one moment.
Judge, if I could be heard as the PC while you're reading.
Go ahead. No, I've already
Yes,
read.
Judge, for the charge of burglary, it requires a showing of intent to commit a crime, therefore within. I don't show during the four corners of the affidavit that there's any allegation of intent to commit crime within. I understand there's also a subsequent charge of criminal mischief. I don't believe that charge applies to within. I think the criminal mischief applies to the screen that was broken into in commission of the burglary, not within the dwelling itself.
State's response.
Just one moment, Your Honor.
A family living.
Your Honor, I
in
would
residence.
argue that the crime they intended to commit therein was a trespass, being that they were sleeping in one of the rooms in the house, and also I would point to the criminal mischief of the window, Your Honor.
All right, well, trespass is a lesser included of burglary, but the court finds the burglary is, there's sufficient facts for probable cause for burglary because the facts are sufficient to conclude that the defendant entered with the purposes of receiving lodging services without payment under the circumstances. And so I do find probable cause for the burglary. I accept your argument on the criminal mischief because there were two people in the structure, and there's no evidence as to whether this defendant actually damaged the property. So therefore, I find probable cause on count one burglary. No probable cause on criminal mischief. Defendant will be ROR'd on count two. With respect to count one, the burglary of a dwelling. One moment. I'm going to set the bond on that at $1,000. And Ms. Moore, you're not to return to 3920 Sutton Place Boulevard in Orange County. Unfortunately, you are out on bond on felony charges in case 19 CF 14958. The court will revoke your bond on that case, and you'll be held on a zero bond due to the probable cause for a new felony offense being committed. And if not previously appointed, the public defender will be appointed to represent you on that case as well. Your next court dates will be provided. Thank you.
Thank you, Judge.
All right, sir, your name?
John Robinson.
Mr. Robinson, all right, good morning. I'm Judge Epperson. I will appoint the public defender to represent you in this case, so you now have legal counsel. Having reviewed the police report, I do find probable cause for burglary of a conveyance. Pre-TR history?
He has no Florida history. He has multi-state history. His last conviction was in 2008 for DUI.
All right, your bond will remain as it's been set, which is $3,500. You're not to return to 2207 Savoy Drive. That's the location of this alleged burglary of a conveyance. And you're not to have any contact with Mr. Augustus Rivers, the alleged victim, who apparently took you to the ground, according to the affidavit, in the immediate aftermath of the burglary. No contact with that individual. Your next court date will be provided.
Yeah.
The next person I had here was Taquane Williams. I'm not sure.
That's what I have.
All right, sir, good morning. Your name?
Hey, how you doing? My name is Taquan Williams.
All right, Mr. Williams, I'm Judge Epperson. I will appoint the public defender provisionally in this case to represent you. I have reviewed the police report. I do find probable cause for 3 offenses: possession of a weapon by a convicted felon, carrying a concealed firearm, and possession of ammunition by a convicted felon. The bonds in this case will remain as they've been set, which is $5,000 on count 1, $2,500 on count 2, and $5,000 on count 3. Obviously, you're not to possess any firearms or ammunition as a condition of your release should you make bond. Your next court date will be provided.
Objection, Your Honor. For the record, do you plan on honoring your oath of office and upholding the United States of America Constitution? Okay, one thing we have to set up first is status. We haven't never acknowledged the status of me, far as me being a state citizen and not a United States citizen. And understand Article 4, Section 4 of the Constitution declares every state is a union republican form of government. And Sherrard versus Cullen, the Supreme Court case, declares that for a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because the exercise of constitutional right. For the record, Your Honor, this court has not proven jurisdiction, which is required by the common law. So are we proceeding this case under Article 1 Legislative Tribunal, or are we operating this proceeding through Article 3 Constitutional Court under common law?
Okay. You can talk to your lawyer about that. I can tell you we're proceeding under the Florida statutes, and that does conclude the
Objection,
hearing
Your Honor,
today.
he is not representing me.
Your objection is overruled, and this hearing is over.
I have a copy of my. Okay.
All right, good morning, sir.
Morning.
Your name?
Earl Lockett.
Okay, Mr. Lockett, one moment. This was a reset, I believe. Mr. Lockett, I'm going to appoint the public defender to help you in this case, to represent you as your lawyer. I've reviewed the police report and I find probable cause for trespassing. This pen's not working.
Can I please do it?
Just a second.
I think you might be right. Do you have an offer now? This is just a straight trespass, but.
Yeah, to an offer.
I'm setting your bond at $250, Mr. Lockett. You're not to return to the Aldi's located at 5524 West Colonial Drive. Don't go back to that location. Your next, I know this. Just one moment. I know the state and defense were talking. Counsel for defense, did you have anything to put on the record?
Yes, I was just trying to say, there is an offer to resolve the case. I just want to make sure we don't have any probation violations. I just have a brief moment.
Sure.
Mr. Lockett. Yes, Judge, after speaking to Mr. Lockett and the state, he'd like to resolve his case. The state can announce an offer on the record.
All
Yes, Your
right.
Honor. The state's offer in this case is an adjudication of guilt to trespass on property after warning. The state's offer is credit time served with a no return to the scene and costs, Your Honor. Court costs, cost of prosecution, cost of defense.
Mr. Lockett, if you wish to enter a plea of guilty and accept the state's offer, please raise your right hand to be sworn. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
You can put your hand down. Now, Mr. Lockett, do you understand by pleading guilty to trespassing that you're giving up your right to have a trial?
Yes, sir.
Have you discussed this matter with your lawyer?
Yes, sir.
Are you today under the influence of drugs, alcohol, or medication?
Yes, sir.
Has anyone made any promises or threats to persuade you to plea today?
No, sir.
Understanding these rights and consequences, do you wish to enter a plea of guilty to trespass on property after warning?
Yes, sir.
And is the defense waiving any deficiencies or defects in the charging instrument?
Yes, Judge.
I find a sufficient factual basis, Mr. Lockett, to accept your plea of guilty. I accept your plea, adjudicate you guilty, and sentence you to 3 days in the Orange County Jail with credit for the 3 days that you've already served. Court costs are $273, $50 cost for the public defender for a total of $323. That must be paid to the Orange County Clerk of Court within 120 days. And Mr. Lockett, do not return to that Aldi's at 5524 West Colonial Drive.
Yes, sir.
All right, you have 30 days to appeal. Thank you.
Yes, sir.
Okay, Anthony Harris, did he bond? Your name, sir?
Tyrone Hollinger.
Okay, so yeah, I'm making inquiry. Okay, so let's just address that. I'll come to your case in a moment, sir. So Anthony Harris, 21 MM70. I've been informed by corrections or the officer here that that it's mental health. I was going to say officer or deputy. Is it? Officer. All right, Officer Vegas. That it's a mental health.
I would waive. We represented Mr. Harris previously, and I would waive.
Okay, so his initial appearance is waived. The bonds will remain as they've been set. The court finds probable cause. 500 count 1, 100 count 2, 100 count 3. And the defendant is not to return to the Denny's at 351 East Main Street. And Mr. Hollinger is now before the court. If you could step up to the microphone. Anyone here on the Hollinger case? No? Okay.
Judge, if I could be heard in regards to probable cause.
Okay, go ahead.
Yes, Judge. The statute in regards to battery by strangulation requires an allegation of specific restriction of airflow or blood flow through the body. As a final end line on the arrest affidavit, the officer acknowledges that's what he's being arrested for, but there's no allegations by the victim or any other witness to the crime at the time as to any restriction of airflow or blood flow.
State's response.
Is the victim here in this case, Your Honor?
I don't believe so. Is Brianna Richardson here today? She's not there.
I don't believe I see that element in the affidavit, Your Honor.
All right, I concur with your arguments, Mr. Holland, Mr. Robinson.
Yes, Judge.
So, Mr. Hollinger, there's 2 allegations in the affidavit. The court finds no probable cause on count 2, and you'll be released on your own recognizance on count 2. However, the court does find probable cause for battery in count 1. From PTR, history?
He just has one traffic conviction, December the 29th of 2020. He has an open traffic case in Seminole County.
Okay, I'll take no action on the open traffic case from another jurisdiction. On the battery charge, your bond is going to be $2,500. You're to have no contact whatsoever with Ms. Brianna Richardson. You're not to return to 1695 Lee Road, and you're not to possess any weapons or firearms. And your next court date will be provided. All right, public defender is appointed. All right, good morning, sir. Your name?
Reginald Taylor.
All right, Mr. Taylor, I'm Judge Epperson. Public defender will be provisionally appointed to represent you in this matter. So counsel's here to your left at that first table. Having reviewed the police report, I do find probable cause for false imprisonment as well as tampering or attempting to hinder a witness communication. Criminal history,
5 felony convictions, 9 misdemeanor convictions, 2 failure to appears.
right? Based upon the underlying factual predicates supporting the charge, your bond on count 1 is going to be $10,000. Your bond on count 2 will be $2,500. You're to have no contact whatsoever with the alleged victim in the case. I would ask PTR or anyone else here if they have the identity of that victim. I didn't see it in the affidavit.
Kamana Jones, I think it's pronounced Kamana Jones.
Tiana?
Kamana with a K.
Kiana?
Yeah, no.
I'm sorry, if you could just spell it.
Kaimana.
Okay, Kaimana Jones. You're to have no contact whatsoever with Kaimana Jones. No contact means absolutely none, no third-party communications, no emails, no telling one person, tell Kaimana this. So no contact, and you're not to possess any weapons or firearms. Your next court date will be provided to you. Thank you. All right, good morning. We have someone here. All right,
morning.
let's identify the parties. First of all, can you please tell me your name, ma'am? Okay, and just speak up, and maybe the microphone would be dropped a little.
La Angel Wilcox.
Okay, Ms. Wilcox, I'm Judge Epperson, and we have someone here from the public. Ma'am, your name?
Yes, I'm her mother, and I am Annette Wilcox.
Okay, Ms. Wilcox, you are listed in the report as an alleged victim. Was there something you wanted to say today?
Yes, I do. I am a victim, but the way the situation happened, my daughter, La Angel, got into it with a sister, so that's how I became the victim trying to break it up. My other daughter, provoked this situation. Now, when the police was called, the police came in. He never asked her any questions at all, being that she was kind of being, I guess, a little hostile and aggressive right then. They just tackled her down. And then it became, I guess she started to resist somewhat. But I am here also because she is under, I have the paperwork here, she is under mental health evaluation with Judge Barbara Leach. And I'm asking Judge Efron if you would consider, please, I need my daughter home, I need her to get help. It's already in the system, the Orange County system, that she's supposed to be admitting herself into Expire. But what I'm saying is, she has been doing great. This is not the place for her. We're just trying to get her help. The other daughter does not live with me. She is the only one there with me right now. And please,
All right, just a moment. State, we have an assistant state attorney here as well as an assistant public defender. State, did you have any questions of Ms. Wilcox?
No, Your Honor, thank you.
All right. Mr. Robinson, do you have any questions?
Yes, briefly. So do you think it would be in both your best interest and your daughter's best interest if she were to return home?
oh, absolutely. We was not even arguing or anything.
Are you
It was
afraid of
the
your
sister,
daughter?
and she doesn't live there.
Are you afraid of your daughter?
Not at all, no.
And if there was any subsequent problems after today, you wouldn't have an issue calling police or to intervene if there was any subsequent violence, would you?
If what now?
You wouldn't have any issue contacting law enforcement if there's any issues going forward in order to ensure your
Oh,
safety.
if there was an issue, I would contact law enforcement, absolutely.
Nothing further.
Okay, just one moment. There's actually a second case, yeah. So it's 21 CF 2441 and 21 CF 2419, but I believe they rise out of the same incident. Just one moment, I didn't catch that second affidavit.
Yes.
PTR, what information do you have?
She has 2 misdemeanor convictions, and she's currently on state probation with a violent offender hold.
She's on state probation. I didn't hear the last thing you said.
With a violent offender hold. She has a violent offender detainer.
Okay, Ms. Wilcox, the public defender's been appointed to help you in this case. On count 1, the aggravated battery, domestic violence, I find probable cause for the lesser included offense of the misdemeanor battery, domestic violence. And I'm going to set your bond in that case at $100. I also find probable cause for battery count 2, and your bond will be $100. I find probable cause for count 3, battery on a law enforcement officer, and I'm setting your bond at $200 on that case. I Find probable cause for resisting an officer with violence, and your bond on that case will be $100. That's for 21 CF 2441. And then turning to the second case, which is an allegation of battery on a law enforcement officer, 21 CF 2419. Find probable cause, and your bond will be $150 on that case. Should you make bond, you're to have no contact with Shanice Shomo, and you're not to possess any weapons or firearms. I'm not going to order a no return, given the totality of the circumstances.
I don't own any weapons.
Ms. Wilcox, where does Shanice live?
I don't have her address, but she doesn't live with me.
All right.
As a matter of fact, all my kids just moved out. I only have La Angel there.
Okay. All right, so your next court date will be provided, all right, and just make sure that you stay in touch with your lawyer. All right, thank you. Thank you for
I
being
have
here.
a question. So I can bond her out?
Yes.
Oh, okay.
All right, thank you.
All right, thank you.
Well, you can bond her out on these charges. If there's other holds, I just dealt with these charges, but you can bond her out on these charges, okay?
Is there another hold?
PTR, you mentioned a.
Yes, she's on state probation, so she has a violent offender hold. It's a 5-day hold.
Oh, it's a 5-day hold. So can I contact her probation officer? Because under the circumstances of everything that happened that day, it was like, it happened so fast. They didn't even know who she was. They just seen that she was very upset at the time, and they took her down. You know what I'm saying? And then it came into a tussle. I didn't understand that at all.
All right. Ms. Wilcox, thank you for being here today. I do have to move on to the other hearings, all right?
I don't know mechanically, if there's a way I could speak to Ms. Wilcox. I don't know if the.
Okay.
Sir, please tell me your name.
Michael Clark?
Okay, Mr. Clark. Is anyone here for Mr. Clark?
If you.
All right, good morning, ma'am.
Email you can.
Good afternoon,
Can you
Your
please
Honor.
tell me your name?
I'm Gloria Rivera Lorenzo.
Okay, Ms. Rivera is the alleged victim, and she's here today. Ms. Rivera, if you wish, you do have the right to briefly be heard today. Is there anything you wanted to say about this matter?
Your Honor, the only thing I could say is that I do not want Mr. Clark around me or my kids. And for the first time, I come to you, so you could please put an order of protection against him and for him not to get close to me or my family or anything like that, sir.
Please, man, please. Just,
All right.
no.
Your Honor, I'm very afraid of him. I do not want him close to me. I come from New York. I don't have nobody here, just me and my kids.
All right, just one moment. Thank you for being here. State have any questions? State or defense have any questions? of
Just-
Ms.
just briefly, Your Honor,
Rivera
it says-
Concerning the issues that we're here for today.
Yes, Your Honor, just briefly, it says that your children were present during the incident, is that correct?
Yes, Your Honor, and my kids were removed because of all this. They can't be at the house until CPS says that they could come back.
Okay, nothing further, Your Honor, thank you.
I don't believe he qualifies for the public defender. It's $1,400 every 2 weeks. That would be
I mean, dependent.
none.
He doesn't
Yeah, so,
qualify because the cutoff is
yeah.
1326.
Yeah. Okay, Mr. Clark, I'm Judge Epperson. You have the right to a lawyer, however, you don't qualify for the public defender. So if you're going to have a lawyer, you'll have to hire your own.
Well, excuse me, I'm sorry, but I put the total down, but I bring home like 400 every 2 weeks because of child support. She just told me a monthly or something like that. I'm not sure what she.
Okay, you fill out an application for the public defender's office, and at the bottom of that application, it says, a person who knowingly provides false information to the clerk of court in seeking a determination of indigent status under section Florida statutes commits a misdemeanor punishable up to 1 year in jail. I attest that this information is true and accurate, and in your own handwriting, you filled this out, correct?
Yes, I got.
Right, and you wrote that you make $1,400 every 2 weeks.
Yeah,
Is that correct?
That's the gross, but when I bring the child support home, it's like 400. But she just told me to put a monthly, like how much you make a monthly. I'm like, that's what I did.
Okay, well, I'm going to take you at your word, and you don't qualify for the public defender's office. All right, having reviewed the police report, I do find probable cause for battery, domestic violence. History from PTR?
3 felony convictions, 6 misdemeanor convictions, and 1 FTA.
And what, if you have the, what were the substantive offenses on the 3 felonies?
DUI, battery on a Leo, and resisting without violence.
Okay, 2 of those 3 were misdemeanors. Did you have 3 felonies?
Battery on a Leo, 2, and 2. And it just says personal crime. I can look it up.
Your Honor, I may have that information if you'd like it as well.
Yes, please.
Two counts of battery on a law enforcement officer, Your Honor, and 1 count of F3 resisting officer with violence.
Okay, all right. All right, Mr. Clark, you're of course presumed innocent. The court's job today is to determine probable cause, and I do find probable cause for battery, domestic violence. Given the underlying facts that are asserted in support of the charge, I'm setting your bond in this case at $5,000.
Okay.
Should you make bond, you are to have no contact whatsoever with Ms. Glorima Rivera. No contact means none, no emails, no third-party communications.
I understand.
None whatsoever. You're also not to return to 5003 Aventura Boulevard. You're also not to possess any weapons or firearms. Your next court date will be provided, all right? All right, thank you for being here today.
The case before this one, I know you said no contact with this victim. Did you want me to put no hostile contact with the mother or no?
Yes, no hostile contact with Annette Wilcox also.
Thank you.
Thanks for that, yeah. All right, good morning. Your name?
Chase Davis.
Okay, Ms. Davis, I will appoint the public defender to represent you in this matter based on your application. So you now have legal counsel here to your left. I have reviewed the police report, and I see that we have maybe Mr. Justin Vickers here. Are you Mr. Vickers?
Yes, sir.
All right, Mr. Vickers, do you have anything briefly you want to say to the court since you're the alleged victim?
I do want contact, so I want her to be able to come back to the house. It was all a misunderstanding. She has no prior, no history of getting arrested before. This never happens. She's not a violent person. We rarely argue, this kind of stuff never happens, so it's all a misunderstanding.
All right. State or defense have any questions?
Just briefly, Your Honor, do you think drugs or alcohol were a factor in the incident that occurred?
Not at all.
Nothing further, Your Honor.
Nothing from the defense.
Any history?
No history. She qualifies for straight PTI.
All right, Ms. Davis, you're going to be placed on pretrial release, supervision, non-monetary conditions. However, you're to have no hostile contact whatsoever with Mr. Justin Vickers. No hostile contact obviously prohibits any acts of violence, but any threats of violence. And until further order of the court, you must maintain a separate residence, all right? So you can't live at 1325 Villa Lane, or if you're living there, he can't live there because you have to maintain a separate residence. You understand that?
Sir.
Take those conditions very seriously, otherwise you can wind up back in jail for violating a condition of release. You have to follow all of pretrial release's rules too.
Okay.
All right, thank you. All right, thank you.
Okay.
Correct. Yep. Thank you. Sir, your name?
Stevie Lamar Fulton Senior, sir.
All right, Mr. Fulton, good morning. And ma'am, your name?
Yvette Simon.
All right. Yvette Simon, Ms. Yvette Simon, you have the right to be heard today. Is there anything you wanted to say to the court?
This whole thing got blown out of proportion.
when the officer came at our home, we was getting into argument. But when the police officer asked me to come out to the street, he showed me a paper that me and my husband had a long time ago, and I explained to him that we went to court on the case, and the judge said that we could be together, but otherwise we wouldn't. So he said that he didn't see it on the case that it was resolved, but we went to court. We had Miss Sweet. The attorney was named Miss Sweet. But we had gotten into an argument, so I asked him to leave. He kept saying, okay, and I asked him to go. He said, I'm gonna go. And I asked the officer, I said, that's all right. And the officer said, no, I'm not going to. I said, well, just wait. And he was finna leave, and he kept on digging and digging. But he didn't, Steve, he didn't say nothing. He was upset because he said he didn't want to be going to jail for a misunderstanding that we had.
All right, Ms. Simon, thank you. State or defense have any questions?
Nothing from the state, Your Honor.
Nothing from the defense right now.
All right, history?
10 felony convictions, 2 misdemeanor convictions. He also has reporting requirements.
Okay. Mr. Fulton, you don't qualify for the public defender's office, so you do have the right to counsel. However, you would have to hire your own. I'm showing 800 weekly with no dependents. All right. I find probable cause for violation of a domestic injunction. Setting your bond in this case in the amount of $750. Should you make bond, you're not to return to 3704 Ranchwood Road. If you have personal belongings there, such as clothing or toiletries, I'd grant a one-time return with the assistance of the sheriff's office. And you're to abide by all injunctions that may be in place. I realize that injunction may have been taken out years ago, but until it's dissolved, you have to abide by that injunction, which would mean no contact with Ms. Avetta Simon. All right, make sure you comply with all of those conditions. Your next court date will be provided to you. Thank you.
Thank you, Your Honor. Yes, sir.
Thank you. All right, sir, your name?
Mike Furbish, Your Honor.
All right, Mr. Furbish. All right, good afternoon, ma'am. Your name?
My name is Dr. Melissa Fogel.
Is your name Dr. Melissa Fogel or is your name Melissa Fogel?
Melissa.
Okay.
The full term, sorry.
All right, Ms. Fogel, you're the named victim in the case, and so you have the right to be heard, and I probably should have clarified this for everyone. The main purpose of being heard today stems out of the nature of this hearing and your right as a victim to be heard. This hearing is about determining whether or not bond's appropriate and any conditions of release. So how you feel about those things is important for the court to consider. Did you want to be heard?
Yes, please.
All right.
Your Honor, we've been under a tremendous amount of stress. We have a special needs child. Our primary caretaker has been out with COVID for 3 weeks. This is highly unusual. It is a misunderstanding. I was significantly misled on how to proceed. So I request that it's dismissed and that there is contact. Our primary residence has 2 separate residences with separate entrances, and I have secured a team of professionals to help diffuse and facilitate peacefully. And this is a misunderstanding.
All right. State, wish to ask any questions?
No, Your Honor.
Defense?
Yes, briefly. So do you think it's in both your best interest and the interest of your family that you have no hostile contact with the defendant in this case?
You're saying no hostile contact as in contact, but...
As in, there would be a restriction that any violence, of course, certainly wouldn't be allowed. Any arguments and stuff would be a violation, but you could have contact in a non-anger-based or hostile way. Would that be best for you?
Correct. The factors suggest that could...
Nothing further.
All right. And any history?
No history, Your Honor. He qualifies for straight PTR.
Okay, just a minute.
Judge, if I could briefly be heard as the probable cause, there's an allegation in the affidavit of...
All right, well,
However.
He doesn't qualify for the public defender's office, or,
I think we're still appointed provisionally due to the COVID
well,
order.
if I appoint you provisionally, you are.
Okay.
Are you asking to be appointed provisionally?
I would be asked to be appointed provisionally.
Mr. Furbush, do you want me to appoint the public defender provisionally to assist you today? He wants to say something in your behalf.
That would be appropriate, yes. If it wouldn't, then no.
All right, I'll appoint provisionally. Go ahead.
Yes, Judge, there's an allegation of an injury in the affidavit. However, there's an allegation of actual contact in regards to a battery on the four corners of the affidavit. I understand there's some issue over a cell phone. But I don't believe there's any actual physical contact that constitutes a battery.
Your Honor, if I may respond, the affidavit alleges that the defendant pushed the victim after he had grabbed her phone, which is enough to constitute a battery under the statute, Your Honor.
All right, based on the totality of circumstances, I do find there's probable cause for the battery on that threshold. With no criminal history, 52 years old, and the facts as they're contained in the report, I will go ahead and place you on pretrial release, Mr. Furbush, with non-monetary conditions. However, you must have no hostile contact whatsoever with Ms. Melissa Fogel. No hostile contact obviously prohibits any acts of violence, but also any threats of violence. I'm also ordering for now, until further order of the court, that you not return to 1504 Northwest Moreland Drive. You may return one time with the assistance of the sheriff's office for the acquisition of important personal belongings such as clothing, toiletries, or tools of the trade for work, and you're not to possess any weapons or firearms. You can talk to legal counsel about the possibility of getting that modified, but for now, that's the order of the court. All right, so just make sure that you comply. Your next court date will be provided. Thank you. Thank you.
Thank you.
Okay, your name, ma'am?
Garcia.
Okay, Ms. Garcia, the court has reviewed the police report. I will appoint the public defender to represent you based on your application. I find probable cause for battery. Criminal history?
No history. No history, Your Honor, but she does have an active warrant out of New Mexico.
All right, your bond will be $500. Your, Ms. Garcia, your bond is $500. You're to have no contact with Carlos Lebron. You must not return to 321 Nightland Court, and you must not possess any weapons or firearms. Your next court date will be provided. All right. I think we're, that's actually kind of the end of our line here for now. So it is approximately 12.
Judge,
Yeah.
I had the defendant brought back in. He has reporting requirements, and you have to state that on the record.
Okay. And you had indicated that earlier.
Here's the name.
Yeah. Okay, Mr. Fulton.
Yes, sir.
I've been informed by our staff here that you have reporting requirements because of prior conviction.
Oh, yes.
And so if you are released from custody, you have to comply with those reporting requirements immediately. Okay, I'll indicate in the order so there's some specificity within 24 hours. All right, so make sure you comply with those reporting requirements.
Yes, sir.
Thank you. Go ahead.
Do we have a Creole? You didn't do the Creole?
Huh?
The Creole interpreter.
I can't hear you.
21MM1455. Yeah, we can't hear. I can't hear anything.
I'm sorry. The Creole interpreter.
We
Did
can't call it now.
We can't
We'll
call
it later.
Okay. We have a Creole interpreter case coming up today.
Yeah, you reviewed it already, Judge. I just had to, because I have to call language line and,
Okay, but was the person,
no, we didn't call the case.
okay, all
I
right,
have it, I took it out.
okay. All right, so folks, it is approximately 12:40-ish. I've got a lot of cases still to review, so y'all enjoy your lunch, and we'll reconvene at 1:45 and hopefully knock everything out. All right, thanks.
Thank you, Your Honor.
Thank you, Your Honor.
Oh, wrong button.
Fulton was no contact, right? Because you told him to abide by all terms.
Which one?
Fulton, the one you just told about reporting requirements. You told him to abide by all terms.
Injunction.
So no contact.
And no contact. I also said that. Yeah.
Okay. No contact.
case we raised.
Like, way earlier?
No, after the first
What was the name?
At 1:30. Yeah, you can tell them that. Alright? Alright.
Really? We scan it to them. Like, I'm scanning it to them as I go. Oh, okay. What's the name?
Maya. Thanks.
No problem.
Thank you so much.
$1,000.
I don't know, I do a lot of things that get done by other people again, right after I do
know,
them.
'cause we scan it to them as we go. Like, I mean, I know they don't get it until Monday, but.
I think it's because they file them here in different, like, there's a bond
Oh.
section and a PTR section, ROR, and that's why. But
Oh, okay.
All right. Want to resume initial appearances if we're ready. And we were going to take the Creole interpreter case first, but we're going to defer on that, and we'll just start with Desiree Guzman whenever we're ready.
Which one you call, sir? I'm sorry.
I believe Guzman is the first one, Desiree Guzman. All right, good afternoon. Your name?
Desiree.
If you speak up.
Desiree Guzman.
All right, Ms. Guzman, I'm Judge Epperson, and we have someone here from the public. Sir, your name?
Jafar Fortunat.
All right, Mr. Fortunat, you are named in the police report as the alleged victim, so you do have the right to be briefly heard today. If there's anything you wanted to say about bond or conditions of release, did you want to say anything?
Yes, Desiree is not a violent person. This type of thing doesn't usually happen. I do want full contact, and also the resident that we previously shared, I have removed all of my belongings, and she can go back to the residence upon her release.
All right, State, have any questions?
just briefly, Your Honor, do you think alcohol and drugs were a factor in the incident?
No.
That's all, Your Honor. Nothing
Anything from the defense?
Yes, Judge, just to reiterate, I'm sorry, you would like to have contact with the defendant, correct?
Yes. We
Okay.
do
And you've
share,
already
we do
removed
share.
You've already removed your belongings from the residence?
Yes.
Nothing further.
Is the 2017 Lexus, is that paid off?
No, it's financed.
All right. Based on the totality of the application, I'll appoint the public defender in the case. And I'm setting bond in the amount of $250. Should you make bond, you're to have no hostile contact with Mr. Jeffrard Fortunat. You must not possess any weapons or firearms. And your next court date will be provided. All right, thank you. Thank you.
Thank you.
I believe Bobby Higginbotham might be next. All right, sir, your name?
Bobby Higginbotham Jr.
All right, Mr. Higginbotham, I'm Judge Epperson. We're here for initial appearances. I have reviewed the police report, also your application. Based on your application, I'll appoint the public defender to represent you in the matter. Any word from the victim from pretrial release?
No, no contact was made.
History?
No contact made.
Okay, history?
He just has 2 misdemeanor convictions.
And do you, what were they for?
Battery and DUI.
All right, Mr. Higginbotham, having found probable cause for battery and violation of domestic injunction, your bond on count 1 will be $1,000. Your bond on count 2 will be $1,000. You, should you make bond, you're to have no contact whatsoever with Tamika Higginbotham until further order of the court. You must not return to 6008 Raleigh Street, and you must not possess any weapons or firearms. Your next court date will be provided to you. Thank you. Sir, your name?
D'Angelo
Your last name?
Arte.
All right, I'm Judge Epperson. I believe we have someone here for this case. Ma'am, if you can please tell me your name.
Naomi Saavedra.
Ms. Saavedra, as the named victim in the case, you have a right to be briefly heard today on bond questions and issues of release. Did you want to say something?
Yeah, I do. I basically just wanted to say that the entire situation was a misunderstanding, and I just wanted to say that he's really not a violent person. He's never touched me, harmed me, or made me feel uncomfortable or unsafe or in danger at all. I think I'm pretty smart enough that I love my life more than to put myself in danger. And I just wanted to say that I wish to have contact with him and for him just to come home again.
State have any questions?
Just briefly, Your Honor, do you think alcohol or drugs were a factor maybe in what happened that night?
No.
Nothing further, Your Honor.
Defense?
Nothing further.
Setting bond at $250. Should you make bond, Mr. Marte, you're to have no hostile contact with Ms. Naomi Saavedra. No hostile contact obviously prohibits any acts of violence, but any threats of violence or acts of intimidation. And your next court date will be provided. Public defender's been appointed. Thank you.
Would I have to come here, like to Orlando for court, or is it over the phone?
You'll receive notice, but it will be at the Orange County Courthouse, yes. All right, ma'am, your name?
Bianca Murillo.
Okay, and I believe we might have someone coming in here, maybe German Hernandez. All right, good afternoon, sir. Your name?
German Isaac.
Your last name?
Sandoval.
All right, sir, you're the named victim in the case. You have a right to be briefly heard on the questions of bond and conditions of release. Is there something you wanted to say?
Yeah, I just want to say that this was is understanding. Bianca's not an aggressive person. This is the first time this happened, and yeah, I want to have full contact with her. I want her to come back home with me and my kids. And this is the first time that this happened. She's not an aggressive person.
Any questions from state or defense?
Just briefly, Your Honor, were the children present at the time when this happened?
No.
You said your kids, and do you think alcohol was a factor?
No, sir.
Nothing further, Your Honor.
Defense?
Nothing further.
Bond's $250. Ms. Murillo, should you make bond, you're to have no hostile contact with Mr. Hernandez. No hostile contact prohibits any acts of violence, but also any threats of violence or acts of intimidation. Make sure you follow those rules, and your next court date will be provided.
Thank you.
Thank you.
Yeah.
All right, sir, your name?
Murillo.
All right, Mr. Murillo, just one moment. Let's see, is in here? No, okay. All right, I'm Judge Epperson. I've reviewed the police report, and I find probable cause for battery domestic violence. I will, again, appoint the public defender in the case. History?
3 felony convictions. Last conviction was forgery.
Were any of those of a violent nature?
No, Your Honor.
Mr. Murillo, your bond is $500. Should you make bond, you're to have no contact whatsoever with Miss Stephanie Mason. You must not, for now, return to the Howard Vernon Motel at 600 West Colonial Drive. If you have personal belongings there like clothing and toiletries, you could go back one time with the help of the sheriff's office to acquire those belongings. Your next court date will be provided.
Yes, sir.
Thank you.
So I'm still going to be in custody, Your Honor?
I didn't hear you?
Yeah, I'm still going to be in custody?
Well, you have a bond, so you can bond out if you're able. On this case. All right. Good afternoon, sir. Your name?
My name is Pat.
All right, Mr. Patton. Can I see that? Let's see the chart there. There's 1 dependence. That would mean 2 in the house. 34. Oh, we just there. All right, I will appoint the public defender to represent you, Mr. Patton. The court finds probable cause for stalking, domestic violence, from PTR history.
5 felony convictions and 2 misdemeanor convictions and 1 FTA. Most of the convictions are possession of cocaine, possession of cannabis.
Any contact with the victim from either the state or PTR?
Contact was made. They stated
Any
that they
feedback?
would- They stated that they would attend IA.
Okay. All right, Mr. Patton, you're obviously presumed innocent, but the allegations supporting the finding of probable cause are concerning. Your bond is going to be $10,000. Should you make bond, you're to have no contact whatsoever with Tiara Simmons. No contact means none. No third-party communications, no emails, text messages, or any other type. You're also not to return to 7654 Forest City Road, and you're not to possess any weapons or firearms. Your next court date will be provided. Thank you. All right, sir, your name?
Solano Figueroa.
Tell me your full name.
Angel Joel Solano Figueroa.
All right. State, I know there was a I know there was a third-party witness that suggested there was some touching here, but you have anything else to add to a probable cause equation?
Moment, Your Honor. No, Your Honor, I also see that. It was a third party who reported it.
Right. Any commentary from the defense? Public defender is appointed.
I have no commentary.
All right.
Unless the state has some supplemental evidence, but based on the 4 corners, I have no commentary.
Okay, while a probable cause finding and a prosecution can be predicated upon statements other than by an alleged victim, the court finds that the facts contained in this affidavit are insufficient to satisfy the question of whether there was a touching against the alleged victim's will. So the court finds no probable cause. You'll be released on this case today. That does not mean the state cannot prosecute. It just means that right now I don't have cause to keep you in custody, all right? So just make sure that you keep the clerk of court updated with any address changes if there are any, all right?
Thank you.
Thank you.
Judge.
Oh, timeout. There were a couple of other cases, but given my finding of no PC, no action will be
No
taken. Yes. All right, thanks. Ma'am, your name?
Amani Tyson.
All right, Ms. Tyson, I'm Judge Epperson. Just one moment. I will appoint the public defender to represent you in this case, so you now have legal counsel. I have reviewed the police report and find probable cause for battery. PTR history?
She has no history and qualifies for straight PTR.
No history, and then
She qualifies for straight PTR.
just contact with the alleged victim, Juan Perez?
No contact was made. We didn't have a valid phone number.
All right. All right, Ms. Tyson, you'll be placed on pretrial release supervision, non-monetary conditions. You have to follow all of the rules of the pretrial release program. And then I'm going to give you a couple of special conditions of release, so make sure you follow these. For now, until further order of the court, you're to have no contact with Juan Perez. No contact. All right, that means you have to maintain a separate residence, obviously. You cannot possess any weapons or firearms. And your next court date will be provided.
Yes, sir. Would it be like a letter sent in the mail?
Right, hello, sir, your name? You don't have to, I'm not going to swear you in right now. Your name, though?
Deontay Walker.
All right, Mr. Walker, I'm Judge Epperson. I believe we have someone here for this case, too. Ma'am, your name?
Yes, it's Shamika Boyd.
Okay, Ms. Boyd, since you're the named victim in the case, you do have the right to be briefly heard today as to bond and conditions of release. Was there something you wanted to say?
Yes, I just wanted the charges to be dropped because when I called them, I just wanted them to talk to him because he was drinking a little bit and I just wanted them to talk to him. We all the way from Georgia and I didn't want none of this to happen.
All right. State have any questions?
Nothing from the state, Your Honor.
Defense?
Nothing further.
History?
He has no history, Your Honor. He qualifies for straight PTR.
Is your present, where are you presently living?
I live
We
with,
stay together.
Yeah.
we both from Georgia, Your Honor, and I have.
Can't hear you.
I said we both from Georgia, and I have a job that I have to attend tomorrow.
Okay. All right, defendant will be placed on pretrial release supervision, non-monetary conditions. Mr. Walker, it's very important that you follow these rules, that you have no hostile contact with Ms. Shamika Boyd. No hostile contact obviously prohibits any acts of violence, but also any threats of violence. Also, you must not return to the Clarion Hotel at 8444 International Drive.
All right, thank you.
Just a minute. Oh, yeah. Okay.
Your Honor,
You don't qualify for the public defender, so you will have to hire your own attorney. Yes?
Can you state that if he can return back to Stone Mountain, Georgia? He stays in Georgia, just state on the record that he can return back to Stone Mountain, Georgia.
Right, that's no longer an impediment, though, to pretrial release?
No, he can still get PTR.
Right. Yeah, he can return to Georgia. That's fine. And you're to have, again, no hostile contact.
Thank you, sir.
Next court date will be provided.
Okay.
There was no dependence in 600.
So, do he have a bond?
He's going to be released later
Oh,
today.
okay,
All right,
cool.
Thank you.
Thank you.
Your name, sir?
Ramjelis Alegre.
All right, Mr. Alegre, the court's going to appoint the public defender to represent you in this case. You have legal counsel here sitting to your left. I have reviewed the police report, and I do find probable cause for possession of synthetic cannabis. And also, there is a open container of alcoholic beverage charge. Just a second.
Yes, Your Honor.
Your bond in case 21 CF 2429, which is the possession of cannabis. Of synthetic cannabis, will be $1,000, subject to pretrial release supervision. You're not to possess, ingest, or consume any illegal substances or any controlled substances without a prescription. And although I find probable cause, I'll ROR the defendant on the open container of alcoholic beverages. Your next court date will be provided. Thank you.
Thank you, Your Honor.
So Judge, that's bond plus pretrial release.
Yes, yes, pretrial release. Okay, I think I'm showing the next person would be Mohammed Azim.
He's medical.
Let's see, Azim Muhammad Ali's medical?
Yes.
All right, Public Defender's Office, do you wish to waive his initial appearance?
We would waive.
Okay. I do find probable cause for burglary of a structure in case 21 CF 2408. Defendant's not to return to 604 East Main Street. I am going to revoke bond in case 20 CF 3687. And defendant will be held on zero bond on that case. Next court dates to be provided. Okay. And then Imperial Brown. He bonded, Your Honor. He bonded. Okay. I'm showing Jean Charmant is next, maybe? Your name, sir?
Jean Charmant.
All right, good afternoon. I'm Judge Epperson. I'm going to make a provisional appointment of the Public Defender's Office. I have reviewed the police report. There are 5 listed charges, and the court finds probable cause for 4 of them. The court finds probable cause for count 1, dealing in stolen property, as well as counts 3, 4, and 5, petty theft. I don't find probable cause for what's designated as count 2, use of an anti-shoplifting control device. History?
1 felony conviction, 5 misdemeanor convictions, and 2 failure to appear. Last conviction was 2009 for marijuana possession.
Judge, if I could be heard briefly.
Okay.
In full candor to the court, I don't know how this impacts the probable cause determination, but I do think there might be an issue of the multiple pay thefts arising from the same action. I don't know that, as in full candor, I don't actually know the impact on our probable cause finding to the multiple pay thefts. I just wanted to,
There was 3 separate instances, one designated February 12th, one February 25th, and one February 27th.
Thank you, Judge.
Yep.
Nothing further.
All right. And there's separated incidents. Mr. Charmant, on count 1, dealing in stolen property, bond will remain $2,500. Bond on the 3 thefts will also be $100 each. ROR on count 2. And you're not to return to the target located at 120 West Grant Street. And your next court date will be provided.
Yes, sir.
Thank you. All right, your name, sir?
William Clemens.
Okay, Mr. Clemens, I'm Judge Epperson. I will appoint the public defender to represent you in this matter. And so you have legal counsel to your left there. I've reviewed the police report, the affidavit. There's 3 listed charges. The court finds probable cause for 2 of those 3 charges, and that would be in count 1, burglary of a structure, as well as count 3, possession of burglary tools. Court finds no PC for the theft in count 2. Before determining bond conditions, PTR history?
No convictions, but some out-of-state arrests, simple battery, criminal trespass, stolen vehicle.
All right, the bond will remain $3,500 on count 1, burglary, ROR as to count 2, and $100 bond on count 3, possession of burglary tools. In addition, should you make bond, you're not to return to 3352 West Orange Blossom Trail, the Copart business, and you're also not to have any contact with the alleged co-defendant, Eric Samuel. Your next court date will be provided.
Okay.
Thank you.
Thank you.
Your name, sir?
Keenan Flippins, sir.
One more time?
Keenan Flippins.
Okay, so let me just address 2 cases before coming back to you. Kiana Cohen bonded.
You have a booking number?
We don't have them on our
Okay, because he's in my stack of cases.
Need the inmate number, Judge, and they can look it up.
Okay.
21004989.
Defendant bonded.
Okay, and then I had Patrick Donald in my stack here as well, and that's inmate medical? All right, let's see, Mr. Robinson, I'm making a provisional appointment in the Public Defender's Office on Patrick Donald. He's in medical. You waive initial appearance?
Defense would waive initial appearance.
All right, he'll just have him maintain his bond at 1,000 on the possession of methamphetamine. Court finds probable cause. I know you're waiving, but I reviewed it, so finding PC.
I still like a finding, even with a waiver.
Yeah, Keenan Flippins is now before the court, I believe.
Yes, sir.
Yes, sir. I will appoint the public defender to represent you in this matter, these matters, too. First of all, I do find probable cause for possession of a controlled substance without a prescription, that controlled substance being alprazolam, as well as resisting a law enforcement officer without violence. Your bond will remain 1,000 on count 1 and 100 on count 2. As a condition of release, if you make bond, you're not to possess or consume or ingest any illegal substances or any controlled substances without a prescription. There's a second matter. You've been arrested on a warrant in Orange County. Case number is 20 CF 7891. Count 1 burglary with an assault or a battery therein. That is what we call a PBL. Your bond will remain 0 on that for now. You can talk to your lawyer about seeking a hearing on that, but that's 0 bond for now.
Sir, everybody in that case has a bond. Everybody.
All right, just a moment, but you don't, see. All right, in count 2, false imprisonment, the bond is $5,000. So those are your bond amounts. The public defender has been appointed on each case. And like I said, you can talk to your lawyer about seeking a modification of that with the trial court.
If I could be heard briefly, I just would like to ask the court not make a finding in regards to proof evident presumption grade.
I didn't.
I know, just,
All right.
I know you didn't, but I want to make sure everyone knew you didn't.
Okay, I just didn't know if you wanted me to reconsider making one. All right. Thank you, sir.
I still got no bond, sir?
You have no bond on count 1 of that warrant, yes. Your name?
Tracy Yolanda Coger.
Okay, Ms. Koger, just one moment.
Yes, sir.
I will appoint the public defender to represent you in this case, so you have an attorney. Been arrested on an outstanding warrant for which a court already found probable cause for a burglary of a dwelling with an assault or a battery therein, as well as theft. Based upon the facts that the court relied upon in that case, a bond was set at 0 on count 1 and $500 on count 2 petty theft. Those bonds will remain.
If I could be heard briefly, I would still ask the court not to make a finding in regards to proof evident presumption grade, in regards to the no bond. The court still does have discretion to issue a bond. I think given the fact that my client had previously lived at the address and the fact that that was the resident that she maintained, I think that should be mitigating in regards to considering issuing a bond.
Your Honor, I don't believe you do have discretion. I think it was issued by the KPS, right? The 0 bond?
This is 0 bond on the capias, correct?
So I would just argue against that.
Okay, well, I'm going to maintain the bonds that are in the warrant. Ms. Koger, you were out on bond prior to the offense date that's referenced in the affidavit for the arrest warrant. Therefore, your bond will be revoked in case 20 CF 5763. And for now, it's going to be a 0 bond. I'll appoint the public defender in that case if they're not already appointed.
Can I say something?
Yes.
Okay, the same person is doing this of the last charge that got dropped. It's the same person that's saying that I did this and I didn't. It's a phone call that she keeps making, just like with the battery that just got dropped. Same girl.
All right. Well, that's certainly information that you would want to give to your lawyer because there's always 2 sides to a story, and I have to rely upon what's been sworn to in the affidavit for today's hearing. But you have the right to a trial, and you're presumed innocent of the charges. All right?
So I have no bond?
You have no bond right now on count 1 in the warrant.
Okay.
All right? We'll give you you'll receive your court dates. All right? All right, in the last case, in the Coder case, I gave it some further review. I'm not going to take action on the open pending case that I earlier referenced. I know she's gone, but 20 CF 5763, those are controlled substance and possession of drug paraphernalia. I won't take any action on that if we can undo that. Right. Sorry about that. Your name?
Ismera Luna.
All right, Ms. Luna, you've been arrested for failing to appear in case 20 CF 1371. That's a case that was in circuit court. The circuit court granted you a bond of $3,000 on that case. There is a second case that we have here today, possession of open container of an alcoholic beverage. I do find probable cause for that, but I'll ROR the defendant in 21 MO 267. Public defenders appointed. Just one moment. That covers it. Okay, well, there's another case, 21 MM 1433, possession of drug paraphernalia. Just one moment. My sticky go. I find probable cause for possession of drug paraphernalia. Your bond will be $500. I'll take no action on any other cases based on that finding.
Judge, briefly, did you issue an ROR for the open container, or was there a bond on the open container?
I ROR'd on open container.
Can I ask for a nominal bond on the open container so she could gain time credit for it? If we ask for a small nominal.
All right, I'll keep the bond at $250 on the open container at your attorney's request. All right, $250 bond on the open container.
Judge, did you state a bond on the FTA?
I'm going to keep that at $3,000. Yes, thank you. All right, that concludes these matters. Thank you.
Thank you, Judge.
Sir, your name?
Andrew Osborne.
Okay. Got to wait till the door shuts, don't we? Yeah. All right, Mr. Osborne, I'm Judge Epperson. I will appoint the public defender to represent you in this case, so you have legal counsel. I do find probable cause for the listed charges of possession of tetrahydrocannabinols, possession of cannabis greater than 20 grams, and possession of drug paraphernalia. Your bonds will remain as they've been set on the affidavit, which is $2,000 on count 1, $300 on count 2, and $200 on count 3. So that's bond with pretrial release condition, bond plus PTR, pretrial release. You're not to possess, ingest, or consume any illegal substances or any controlled substances without a prescription. Your next court date will be provided to you.
Yes, sir. Am I pretrial released? Is that what you said?
No, it's bond plus pretrial release conditions, and I've given you the bond amounts that you have.
Yes, sir.
Right.
Is there any way that I can have a bond reduction?
to somebody that's local, the 1250?
Well, no,
I could afford to do that if you could work with me with that.
no, I already put thought into that, and I'm going to keep your bonds as I've announced them. All right, thank you, though. Your name, sir?
Samuel Paul.
All right, Mr. Paul, there's an application here for the Public Defender's Office. I'll appoint the public defender based on that application. There's two listed charges that you're here today on, 21 CF 2420. The court finds probable cause on count 1, the burglary of a dwelling, but no probable cause on count 2 for the criminal mischief. PTR history?
1 felony conviction, 2 misdemeanor convictions, 1 failure to appear. Last conviction was January the 8th for trespass.
All right, bond on the burglary of a dwelling will remain $5,000. You're ROR'd on count 2 criminal mischief, and again, no return to 3935 Sutton Place. Don't go back to that house. All right, thank you. Court date to be provided. Hi, good afternoon, your name?
Daniela Price.
Ms. Price, I'm Judge Epperson. I will appoint the public defender to represent you in this case, so you now have legal counsel sitting here to your left.
Yes, sir.
There are 2 cases. The court finds probable cause for driving while license suspended. Your bond in that.
If I could be heard briefly in regards to bond, on regards to driving license suspended, I think Florida statutes, I can list to you right now, 907.041 still grants a high presumption in regards to non-monetary release, in regards to non-dangerous and non-violent crimes that are enumerated under subsection 3.4. This is not listed as one of those charges, so I think non-monetary release is appropriate unless the court makes a finding otherwise.
All right, I find otherwise. I am going to reduce the bond from $2,500 to $500 on the driving while license suspended charge. On case number 21MM41, I find no probable cause for resisting without violence. State the resisting is predicated upon a switcheroo on the alleged switch between driver and passenger, but I don't find that that meets the elements of obstructing an officer while the officer is engaged in the lawful execution of a legal duty, given the timing of the switch. So defendant will be ROR'd on 21MM41. Your next court date will be provided.
Okay, thank you.
Thank you. All right, good afternoon. Your name?
Lisa Price.
All right, Ms. Price, I will appoint the public defender to represent you in this case. So you have legal counsel sitting there to your left. You have an attorney. Having reviewed the police report, I do find probable cause for the offenses of possession of cocaine and possession of drug paraphernalia. Your bond on the possession of cocaine will be modified to $500. Possession of drug paraphernalia, $500. State or defense wish to be heard of the occasion that Ms. Price is currently in an ROR status on another offense, which I believe is a felony prostitution charge due to the priors.
The defense we heard, I understand if the state would like to hear, they are entitled to go first.
If y'all are not, if you're not speaking into a microphone, I
I'm
can't.
sorry.
It's all-
This defense would like to be heard. I don't think this is a willful felony in the same way as even a petty theft 3 prior or something else would be. Possession of a controlled substance is not the same sort of willful felony as a theft or a grand theft or something along those lines. So I don't think a revocation of bond on the previous case is appropriate. If we could say the bonds as you previously said and take no action.
Nothing from the state, Your Honor.
All right, Ms. Price, when you're awaiting the resolution of an open criminal case, you can't commit other crimes. Otherwise, you might sit in jail on a no bond for months waiting for a court hearing. So remember that going forward. I won't take any action on 20 CF 10378. All right, you'll receive your court date. Thank you.
Thank you, Your Honor.
Judge, you didn't state any conditions, did you? I'm just asking.
I didn't.
Okay,
I
thank
should
you.
have. All right, let's move on. Heck, your name?
Hector Rico?
Okay, Mr. Rico. I'm appointing the, just a second. I'm appointing the public defender to represent you in this case. I've reviewed the police report. I find probable cause for the lesser included offense of battery. Setting your bond at $1,000. Should you make bond, you're to have no contact whatsoever with Mario Gomez. None means none. No third-party communications, emails, anything of that sort. And you're, I'm sorry, I made a mistake again. Although the court finds it's a lesser included, there was some substantial injury according to the sworn affidavit, and your bond will actually be set at $2,000. Okay, so that's your bond amount. And again, no contact. You'll receive your next court dates. All right, thank you.
Just for clarity, I'm sure this is what you had ruled on. I just wanted to make sure that, it was not for the strangulation, correct?
No,
Okay,
lesser included a battery.
Agreed. Thank you, Judge.
Your name, sir?
Eric Samuel.
Okay, Mr. Samuel, I will appoint the public defender to represent you in this case. I've reviewed the police report. There's 3 listed charges. I find probable cause for 2 of those. Count 1, burglary of a structure, and count 3, possession of burglary tools. No PC on count 2, theft, so the defendant will be ROR'd on count 2. Your bond will remain $3,500 on count 1, burglary of a structure, and $150 on count 3, possession of burglary tools. You're not to return to 3352 North Orange Blossom Trail, the Copart business, and you're to have no contact with the alleged co-defendant, Mr. William Clemens. You'll receive your next court date.
Thank you.
Thank you. Hello, your name?
That's Ron Stanley.
Okay, Ms. Stanley, I'm going to get to your case in just a second. I had a case before that maybe it's a bond situation. Jonathan Soto Andujar? Bonded, okay. Ms. Stanley, you've been arrested on an outstanding warrant for which a court has already determined probable cause for grand theft of a motor vehicle, and in the warrant, that judge set your bond at $7,500. So that is your bond amount. You have a lawyer. Your next court date will be provided. Right?
Skip.
What statute number would you like to
Okay.
use for this one? Because
The lesser included?
okay, because that's strangulation. The statute number you put on there is
Yeah.
for strangulation.
Right. Yeah, no, that's okay. I found PC for the lesser included in that. I'll give that to you. Just 784.03, subsection 1.
Thank you.
Your name, ma'am? Your last name, Stevens? All right, just one moment. Okay, Ms. Stevens, you've been arrested on a warrant in case CF 2035 for fraudulent use of personal identification information and fraudulent use of credit cards. court that issued the warrant set your bond at $1,000 for each count for an aggregate amount of $2,000.
Yes, sir.
The offense date in the warrant was February 17th. That's very recent. You are out on bond on a case in which you were arrested in February of 2020. That is case number 2020 CF 788. Involved allegations of dealing in stolen property, receiving money from pawnbroker by false verification, as well as theft, possession of cocaine, and paraphernalia. Your bond in that case is revoked, and you'll be held on a zero bond in 20 CF 788. Also, it looks like you are on an ROR status on a theft with 2 prior theft convictions in case 20 CF 485. Is that 4857 or 4851?
4857.
4857. Your bond in that case is revoked, and you'll be held on a zero bond in that case as well. Public defender will be appointed in all these matters if not previously appointed, and you'll receive your court dates. Thank you. All right, good afternoon. Your name, sir?
Alex Weston.
State, I'm going to give it 24 hours to supplement the record. I'm missing page 3 of the report. If you have what I have, it's odd. It doesn't give the full name of the victim. It sounds like it's a partial report. And then I noticed that I don't have page 3.
Sir, I have it in front of me if you'd like it.
Yeah, if you have it, yes, I'd like to see it.
Could I ask to stay there an extra copy? Okay.
I'll let you see it after I do.
Yeah, no problem.
Okay. Thanks. Oh, okay, so it tells his name, but. Yeah. PTR history for Mr. Weston?
2 felony convictions, 1 misdemeanor conviction, and 1 failure to appear. Last conviction was for petty theft, June of 2020.
Okay, and so based on the information the state provided to me, the alleged victim in the case is Mr. Dennis Walker. Page 2 that's sworn to lays out sufficient facts to find probable cause for burglary of a conveyance. So I'm going to make that finding today. Mr. Weston, your bond is $3,500. Should you make bond, you're not to have any contact with the alleged victim in the case. That was Dennis Walker. No contact means none, all right? No communications whatsoever. Your next court date will be provided. Thank you.
Approach, Your Honor.
Yes, sir.
Just a
Yes, thanks. Your name, sir?
Austin Page Williams.
All right, Mr. Williams. I will appoint the public defender to represent you. I've reviewed the police report. I find probable cause for aggravated assault. Your bond is $2,500. You're to have no contact with Muhammad Pelhoum. You're also not to return to 8442 Clematis Lane. You're not to possess any weapons or firearms. Your next court date will be provided.
Thank you, sir.
Thank you. Good afternoon. Your name? Good afternoon.
I'm sorry.
That's okay. I'm over here.
Latoya Wilson.
All right, Ms. Wilson, good afternoon. I'm appointing the public defender to represent you in this case, so you have a lawyer who's sitting here to your left.
Sorry.
I have reviewed the sworn affidavit. I find probable cause for burglary of a structure in count 1 and criminal mischief in count 2, based upon the circumstantial evidence in the report. Criminal history?
3 misdemeanor convictions and 1 failure to appear. Last conviction was in 2012, resisting officer without violence.
I'm going to modify the bond in count 1 to $1,000. Count 2 will remain $100 on the criminal mischief. Should you make bond, you're not to return to 3509 Forestdale Drive until further order of the court. You're also not to have any hostile contact with Ms. Leslie Mitchell. No hostile contact means obviously no acts of violence,
Yes, sir.
but also no threats of violence or acts of intimidation. Your next court date will be provided. All right, thank you. Okay. Okay, that moves us to the traffic batch. On the home stretch. Osai Fuentes, Marin bonded, okay, that takes care of that. Okay. Okay,
Yeah.
thank you. All right, good morning, or good afternoon, your name? Over here, your name?
Lisa Morris.
Okay, Ms. Morris, been arrested for 2 traffic matters, one driving while license suspended with knowledge, another expired license more than 6 months. I will appoint the public defender to represent you, so you now have a lawyer who's here today. Mr. Robinson from the Public Defender's Office. I'm assuming, State, you don't have a driving record, is that right?
No, sir.
Mr. Horn, you don't have a driving record, do you?
No, Your Honor.
All right.
Just maybe here briefly, as I've previously said today, now in regards to this client, Florida statutes 907.0401 lays out a heavy presumption towards pretrial non-monetary release for charges not listed as dangerous crimes, which are enumerated in subsection 3(4)(a). So in regards to this case, I think a non-monetary release condition is appropriate.
All right, PTR, you don't have a driving record, do you?
I have a criminal history, Your Honor, but not a
Let
driver.
me hear from PTR briefly.
I
Oh,
gave
my
you a
apologies.
copy. I don't have it. I gave you a copy of all the Davids.
Right, but there's not a driving, it's
You want me to
not,
print it out?
no, it didn't have specific traffic information though, does it? No, okay. State?
I have access to her criminal history record, which involves her criminal driving charges, but not her entire.
Okay, summarize briefly.
Your Honor, driving under the influence, PTD, 2014, driving through or within a safety zone.
Just criminal, I don't care about the, I won't take into account the civil.
Just the 2014 DUI, Your Honor.
Thank you. All right, Ms. Morris, in these cases, you'll be placed on pretrial release, supervision, non-monetary conditions. Just make sure that you show up for your court dates. Make sure that you show up for your court dates, and if you have a change of address, make sure you notify the clerk. I do find probable cause in each case, but court dates to be provided.
Any conditions?
Follow all the laws.
Okay. Thank you, Judge.
Rivera Santiago bonded.
Okay, Jason Rivera Santiago has bonded. That takes us to Tevin Brown, I believe. Oh, maybe not. Your name, sir?
Jared Ferris, sir.
All right, Mr. Ferris, before I get to you, there was a case, Tevin Brown. By chance, did he bond?
Have a booking number.
Here's Tevin Brown. I can't hear anything.
2100496.
Yes, he posted bond.
Okay, Mr. Ferris, I'm Judge Epperson. I will appoint the public defender to represent you in this case, so you have legal counsel sitting here.
Yes, sir.
Court finds probable cause for providing false identification to law enforcement while lawfully detained. History?
10 felony convictions, 11 misdemeanor convictions, and 1 failure to appear. The last conviction was for driving while license suspended in 2012.
Right, your bond remains $500. You'll receive your court date. Thank you.
Anthony Harris is mental health.
think we dealt with him yesterday. I don't have him here.
Judge, was this one of the resets from yesterday? Anthony Harris?
Perhaps I wasn't given I don't have his case. Let's keep going with who we have. And
No
Yeah, I don't have his case either.
your name, sir?
Gerald Streeter.
All right, Mr. Streeter, I'm Judge Epperson. Good afternoon. I will appoint the public defender to represent you in this matter, so you have an attorney here sitting to your left today. The court does find probable cause for possession of drug paraphernalia. Your bond is $500. Should you make bond, you're not to possess, ingest, or consume any illegal substances or any controlled substances without a prescription. You'll get your court date. Thank you.
Adam Bradley bonded.
Bradley bonded. Okay, so I believe Mr. England is next. Your name, sir?
England?
Okay, Mr. England, I'm Judge Epperson. You've been picked up on an outstanding writ of bodily attachment with a purge amount or bond amount of $600. So $600 is the key to your release. Otherwise, Brevard County will have a reasonable amount of time to pick you up on this outstanding writ. I would say 48 hours. Right?
Okay.
Thank you.
Yes, sir. Thank you.
Good afternoon, your name?
Hi, Chanel Riley.
All right, Ms. Riley, you've been arrested on a warrant out of Broward County. The bond on the out-of-county
Yes,
warrant, just a moment, it's $1,000 for failure to return a leased or hired vehicle. All right, Broward County will have a reasonable amount of time to pick you up on the warrant. Broward will have 72 hours. Did you want to say something briefly?
yes, sir. I've been dealing with this for like almost 2 years, and they got their car and everything like that. They even came to the house and picked it up. And then I went on Friday to clear up a license, and I got a tag registered for a scooter as well. So I was kind of confused on what was going on with this, because I don't have a car or nothing like that.
All right.
They picked it up and stuff. So they charged me, and I paid for it too. So I don't know what's going on.
All right, well, the state will have the burden of proving your guilt beyond all reasonable doubt, and you're presumed innocent, but I just needed to inform you why you were picked up on a warrant out of Broward County, and I've done that.
Yes.
All right, thank you.
So I'm good. Would I have to pay the fine? I'm sorry, would I have to?
I told you your bond amount, it was it 1,000?
Yes, Judge.
You have a $1,000 bond. If you don't bond out, Broward will have to pick you up within 72 hours.
No problem, I appreciate it.
Thank you. Your name, sir?
Juan Rivera?
Okay, Mr. Rivera, just one moment. County. All right, sir, you've been picked up on a warrant out of Broward County. That's why you're here today. Robbery and battery charges. You have a 0 bond on count 1, the robbery, and a $1,000 bond on count 2. I'll make a provisional appointment at the public defender's office. Broward County will have 72 hours to pick you up on these warrants. Thank you. Your name, sir?
Perez Morales.
All right, Mr. Perez Morales. Just a moment. It's a reset. I believe the state was afforded 24 hours to supplement the record. Any additional information, state?
Not at this time, Your Honor.
All right. Mr. Perez Morales, you're going to be released today on this matter. This does not mean that the prosecutor or state will not file charges. That's totally up to them. This just means I don't have sufficient facts right now in front of me to maintain your custody. So make sure that you keep the clerk updated with your contact information if you change address. Thank you.
Thank you. You have a blessed day.
No PC. Your name? All right, Mr. Gonzalez, you've been arrested on a violation of probation in case 20 CF 12053. I will appoint the public defender to represent you. There's a second case. Let me go back to that one. That you have a $100 bond, oddly enough. You were given a $100 bond on the violation of probation, underlying charge grand theft. A second case, 21 MM 1440, the court finds probable cause for petty theft. Bond will be $500. You're not to return to the Lowe's located at 3500 South Cimarron Boulevard. And your next court date will be provided. Public defender appointed on both.
Your Honor, can I ask a question about the violation of probation? I just started that, and it was a probation that was put in place for.
You know, you might want to keep talking, just a minute. Keep him there for just a minute. Just one moment, we're not done yet. Okay, you were placed on probation on January the 26th. Correction, just a minute. Okay, so you're on probation, as I said before, in 2020 CF 12053 for a felony theft charge. The violation of probation that you were asking about was predicated solely upon failing to report and by not remaining in a specified place. The court now has probable cause to believe that you have also violated your probation by committing a theft while on probation for felony theft. Therefore, the court will find an on-view violation of probation in case 20 CF 12053, and you'll be held on a zero bond on that case. All right, you'll maintain the same $500 bond as previously announced on the other theft, 211440. All right, thank you.
Judge, can I ask you a question?
Yes.
So you want me to raise it to none, or you want me to pass another order on view?
I don't know how y'all do it practically, but
I can raise it to none
I
and
find
then on view.
Yeah, I find an on-view violation for a new law offense and being held at zero bond.
Judge, this is more for my own knowledge. Will probation have to issue a new or supplemental violation going forward?
Yes, they'll. I'll go ahead and put on the record that probation shall review within 72 hours to amend the violation of probation if they deem it appropriate. Yeah.
Thank you, Judge.
Your name, sir?
Sims.
Okay, before I get to you, Mr. Sims, Trammell Heron, did he bond?
No, sir, he's mental health.
Mental health, all right. Let me ask the public defender's office. You waive initial appearance on Trammell Heron?
Judge, I believe this wasn't a reset, so we asked for a one-time reset tomorrow, just for one opportunity.
Okay, I won't be here tomorrow. We'll reset it for tomorrow.
Hey, here will I.
We'll give it one shot on Trammell Heron for tomorrow, a reset. That's not why I'm resetting it, but it's a different issue than COVID, so we'll give it a reset. Mr. Sims, you've been arrested on a violation of probation in case 20 CF 4567. The underlying charge was aggravated assault. The trial court that issued the warrant for the violation of probation, Judge Weiss, set your bond at zero. It will remain zero at this time. However, public defender is appointed to represent you in the case. There's also another matter, I think. Let's see. And that's out of Polk County. There's an out-of-county warrant for failure to appear on a possession of drug paraphernalia case, and your bond on that case is 0. That's Polk County case number 2923. Public defender's provisionally appointed on that case, and Polk County will have 48 hours to pick you up. All right, thank you. Your name, sir? All right, Mr. Jones.
Patient free. Patient Frio.
All right, State, this is Mr. Damian Jones, and I'm reading a narrative that seems to support perhaps a possession of synthetic cannabis or other charge or paraphernalia, but the charging affidavit says City Ordinance 43-3. You have any insight on that?
One moment, Your Honor, I see that as well.
In the meantime, if I could briefly interject, the state is contracted to handle these cases from the city, or is the city need to make their own appearance? I don't know if the state has any input onto that. Because I don't know, the state itself isn't a party to the case, so I don't know that without some sort of knowledge towards a contract between them, their capacity to even testify, not testify, but to provide input.
The city code in front of me. I don't have the city code in front of me, so
It's a disorderly conduct statute, Your Honor.
all right.
Okay.
Statute or city ordinance?
Sorry, the
My
disorderly conduct ordinance, Your Honor.
Okay.
My understanding it's an ordinance, it's a city ordinance where the city ordinance is to violate a state misdemeanor is a violation of a city ordinance.
Okay, it's a city ordinance violation. Do you know whether your client wishes to resolve the case today?
I don't have an offer from the state or the prosecuting attorney. I don't know if you would be inclined to resolve the case from the bench. I don't know if the bench is concerned.
Well, if he wants to plead to the bench, I'm not going to make an offer. I'm not a party. But if
That's
he wants
why
to
I
plead to
was-
the bench, and I'll take a plea today.
Would you be willing to impress upon council what would be, if not, I understand.
I will employ wisdom in imposing sentence. All right, you want to talk to him briefly?
Judge, he's currently out on bond also.
Yeah, thanks. He's ROR'd, right? Okay,
They did speak with him and he said he understands English. He speaks English.
okay,
Yes, Judge, RR.
yeah. Let me make this easy for you. The state's informed the court that it's a disorderly conduct allegation under the code, under 43.3. Is that right, Mr.?
The site,
I don't find probable cause for disorderly conduct. The officer was probably trying to cut a break, but there's not probable cause for that particular ordinance violation. So the defendant will be ROR'd on this case today. No PC.
Nice and easy.
Thank you.
Judge, what about the open case?
No action as there's no PC. Thanks, though. Yeah, I need to articulate that, yeah. Okay. So we have one case remaining, I believe, and it's the one involving the Creole interpreter. I've been informed he might be able to understand sufficient English. We'll see. Sir, I'm Judge Epperson. Can you tell me your name?
Nelson.
Okay, Mr. Nelson. Can you understand what I'm saying to you in English? Okay. It's almost always smart to have a lawyer when you're accused of a crime. Do you want me to give you a lawyer today? I can't hear you. Speak into the mic.
I said I don't have no money to pay a lawyer.
I'm going to make a provisional appointment of the public defender's office today. I reviewed the police report in this case, and the court does find probable cause for battery by strangulation in count 1 and tampering or hindering a witness in count 2. Criminal history.
One misdemeanor conviction. Last conviction was January the 6th, driving while license suspended.
Thank you.
You're welcome.
Just 1 second. Bond on the battery by strangulation will be $2,500. Bond on count 2, tampering with a witness, will be $1,000. You're to have no contact with Nanishka Villanueva Torres. No contact should you make bond. You're not to return to 4506 Silver Star Road. You must not possess any weapons or firearms. Based upon my probable cause finding in this case, your bond is revoked in case 21 MM 580, and you'll be held on a zero bond on that case, which is a resisting officer case. Also, your bond is revoked in case 21 CF 969. That's an aggravated battery charge. Pretrial release is revoked, and you'll be held on a zero bond. In the former case, it was also pretrial release that's being revoked. All right. Public Defender's Office is appointed in all cases, if not previously appointed. You will receive your court dates. Okay? All right, thank you.
Your Honor, do you have one more moment on a separate case? I have
Sure.
Taylor Marie Olson as a reset from yesterday to 228.
You have a case number?
Maybe.
Or inmate number?
I got it.
You have it?
I got it. 4913. She posted bond.
Oh, she bonded.
She bonded, all right.
Oh.
Hear that.
Judge, I have one more matter if we could briefly address it. I understand it's not on the docket, but it's a client that I represent named Jackie Ponder who turned himself in last night. There's an issue. It's a failure to report case. And I don't know if I can get something from the state on the record in regards to action.
Can you get in front of the microphone?
Sorry. Yes, Judge, I have one more case that, it's a case I represent. His name is Jackie Ponder, case number 21 CF 1035 AO. He turned himself in last night. I was anticipating him to be on our docket this morning. I don't know if he's on it for tomorrow. That being said, there was a violation for a failure to report, whereas the officer submitted to me and was willing to appear that he was not seeking to have any action taken on his 2 pending felony cases. I don't know if this is something we can address now. I was hoping we could, considering it's a client I'm involved with and I'm here, but I understand the limitations of.
Yeah.
Received the warrant back served yet. I don't know if they've been served. It's still active in our system.
Okay. It's a little too fresh for me to take action on it. Apparently, it's not even being reflected as served yet.
Okay.
So it'll just have to happen in due course. All right. Sorry about that.
I appreciate it. I would have felt bad if I didn't ask.
All right. Well, listen, y'all enjoy the rest of your weekend, what little is left of it.
You
And
too.
thanks, and if I'm still drawing breath, maybe I'll see you all in about a year and a half.
Thank you, Your Honor.
All right.
Thank you, Judge.
Thank you.
We have one more no contact order, and that's it.
Okay.
I gotta go find all this stuff now.
Thanks. Have a good one.